Welcome back to Justice Judgment. Today's case is not about a landmark judgment, but it is a very important case. As because of this case, people became more aware and concerned about the women's safety. A lot of amendments were also made in the Indian Penal Code 1860, Indian Evidence Act 1872, CRPC related to sexual laws and women's safety. This case is famously known as Mathura rape case. Citation of this case is Tukaram and Others versus State of Maharashtra 1978. Let's get into the nitty-gritties of the case. Mathura was a young girl of the age 14 to 16 years. She was an orphan who lived with her brother Gama. They both were laborers. Mathura used to work at Nunshi's house. Mathura over time developed a relationship with Ashok, Nunshi's cousin. They both decided to get married, but Gama was against their relationship. On March 26, 1972, Gama launched a report that Mathura was kidnapped by Nunshi, her husband Lakshman, and Ashok. Nunshi's husband Lakshman, Ashok, and Mathura were brought to the police station at 9 pm. All their statements were recorded around 10:30 pm. Everyone was leaving, but Mathura was asked to stay back at the police station by the policemen Ganpat and Tukaram. The events that took place later are horrifying and inhuman. Ganpat took Mathura to the latrine and raped her there. He then dragged her to the backside and raped her again. After Ganpat was done, Tukaram entered and fondled with her private parts. But he could not rape her because he was highly intoxicated. The definition of the word rape, according to section 375 of IPC of that era, is in front of your screens. Meanwhile, Nunshi, Gama, and Ashok, who were waiting outside the police station for Mathura, grew suspicious when the police station's lights were switched off and the doors were locked. They shouted and attracted a crowd. Mathura came out and claimed that she was raped by Ganpat and Tukaram. The police was not ready to file an FIR, but under the pressure of the crowd, they launched a complaint. Mathura was examined by a doctor who found that she had no injuries on her body. Her hymen revealed old ruptures. The vagina admitted 2 fingers easily. The age of the girl was estimated by the doctor to be between 14 and 16 years. The chemical examiner did not find any trace of the semen in the pubic hair or the vaginal smear sites, but the presence of semen was detected on Mathura's clothes. The case came for hearing on 1st June 1974 in the Sessions Court. The Sessions judge found that there was no satisfactory evidence that proved that Mathura was below 16 years. The Sessions Court also passed a very weird judgment that Mathura was a shocking liar, her testimony is false and full of improbabilities. It also stated that Mathura had sexual intercourse at the police station, but rape hadn't been proved. She was very sexually active, but finding that Nunshi and Ashok would get angry with her, she had to sound virtuous before them. When this same case was brought in front of the Bombay High Court, the Nagpur bench of Bombay High Court set aside a different judgment from the Sessions Court and convicted both the policemen for section 375, that is rape. The Bombay High Court found that the sexual intercourse was forcible and considered rape since both the accused were total strangers and it was very unlikely for Mathura to have intercourse with them. The fact that semen was not found either on the pubic hair or on the vaginal smear is because Mathura was examined by a doctor 20 hours later and the probabilities that she had taken a bath in the meanwhile is very likely. However, in September 1979, the Supreme Court of India reversed the High Court's ruling and again acquitted the accused policemen. The burden of proof is always on the prosecution to prove each and every ingredient of the offense. Therefore, the prosecution was to prove all the ingredients of section 375 of the Indian Penal Code. The High Court failed to prove that consent of Mathura was obtained by putting her in the state of risk of death or hurt. That means third clause of the section 375 will not be applicable here. There could not be any fear as the girl was taken by Ganpat right in front of her near and dear ones. Being unhappy with the Supreme Court's judgment, Dr. Upendra Bakshi decided to be the first person to write an open letter to the Supreme Court of India. Dr. Upendra Bakshi is a legal scholar and currently a professor at the Jindal University. He found three professors who finally agreed to sign on his open letter. They all were worried that this letter could be held as a contempt of court and they all could land up in jail. But this did not stop them from drafting the letter. The open letter stated that the decision taken by the Supreme Court was sacrificing human rights of women. This letter also rose some very important questions. Why was only Mathura asked to stay back when others were leaving? Why did Tukaram did nothing to rescue Mathura? When Tukaram was intoxicated, why was this not considered as material? Why were the lights shut and the doors closed? Why is it expected for a 14 to 16-year-old girl trapped in a police station by two men expected to successfully raise alarm for help? Does the court really believe that Mathura was so flirtatious that when her brother, her employer, her lover were waiting outside the police station for her, she could not let go of the opportunity of having fun with two unknown policemen, and that too in an area adjacent to a police station latrine? What about the semen marks on the Ganpat's trouser? Why this double standards? Ganpat's sexual habits give him the benefit of the doubt of having raped Mathura, but her sexual habits make the court disbelieve the story of rape altogether. Is the taboo against premarital rape so strong as to which it provides license to the Indian police to rape young girls or to make them subject to their desire in the police station? The open letter also speaks about a few injustices done by the court regarding this case and a few other cases and appeals only one thing, that is to rehear the Mathura rape case. Due to the open letter, a lot of reforms took place in the rape law. Dr. Upendra Bakshi and others prepared notes on the reform of law for rape and aligned offences. They did a very thorough analysis of the rape law. Thanks to the signatories of the open letter and the nationwide women's movement, the Criminal Law Amendment Act 1983 was passed, bringing about a number of changes in the laws relating to rape in India. The changes in IPC were: before 1983, there was no provision to protect the identity of the rape victim. The Amendment Act brought about the Section 228A, which prescribes punishments for printing or publishing information about the identity of the rape victim without her consent, or in the case of a minor, or death without the consent of her next kin. The Amendment Act also changed the definition of rape. Previously, there were 5 descriptions of rape. Under Section 375, the Amendment Act added the 6th description of rape. Before the 1983 Amendment Act, under Section 376, the blanket punishment for rape was imprisonment for a term of up to 10 years and fine. In 1983, a mandatory minimum sentence of 7 years of imprisonment was introduced for rape. For aggravated rape cases, imprisonment for 10 years was decided. The maximum term of imprisonment was increased to life sentences. And lastly, before the 1983 Amendment Act, there was no provision for certain instances of sexual intercourse that are not legally considered as rape. Under the Amendment Act, Section 376A, intercourse by a man with his wife during separation. Section 376B, intercourse by public servant with women in his custody. Section 376C, intercourse by superintendent of jail, remand home, etc. And Section 376D, intercourse of any member of management of staff of a hospital with a woman in that hospital, were inserted and punishment was prescribed. Changes made in CRPC were: before the 1983 Amendment Act, Section 327 stated that all criminal courts were open to the public unless the presiding judge or the magistrate ordered otherwise. However, the Amendment Act of 1983 inserted subsections 2 and 3 in Section 327 stating that inquiry and trial in the cases of rape under Section 376, Section 376A, Section 376B, Section 376C, and Section 376D shall be contained in camera, and the printing and publishing of any matter related to such proceedings without court's permission shall be considered unlawful. And lastly, changes made in the Indian Evidence Act 1872 were that before the 1983 Amendment Act, there was no presumption of absence of consent in rape cases. The Amendment Act 1983 added Section 114, which stated in certain prosecutions of rape, such as rape by a police officer, a public servant of a woman in his custody, if the woman claims that she did not consent, the court will presume an absence of consent. Section 114A is only applicable in cases where rape by a police officer of a woman in his custody or in a police station takes place. Rape by a public servant of a woman in his or his subordinate's custody. Rape of an inmate by a staff of a jail, remand home, or other place of custody of a woman's or children's institution. Rape of a woman in a hospital by a member of the management or the staff of the hospital. Rape of a pregnant woman, and gang rape. Unfortunately, this case is not about justice, but it is the first step towards justice for women's safety. Cases like these have been turning points in women's rights movement in India, as it has led to greater awareness of women's legal rights, issues, oppressions, and patriarchal mindsets. It's also necessary to treat the victim with respect by the people without glamorizing or victimizing the victim. Audio given by Miloni Gala. Research done by Prasad Nagargoje. Thank you for watching our video. Hope you liked it. If you did so, please hit the like button, comment down below, and share our video. Also, for more landmark judgments, subscribe to Justice Judgement.